So Rick, we're up to, I see 24. We're probably we certainly have a quorum. That may be all that are coming aboard.
Okay. Well, then why don't we go ahead and get started? We'll call the meeting to order, and can we please call the roll?
Okay, I'll do that. And I'll start off with Dr. Rick Hildebrandt.
I'm here.
Rob Chapanelli.
Here.
Dr. David Coder.
Here.
Dr. Evan Eiler. Ms. Gail Falk.
Here.
And Dr. Rachel Gatus.
Here.
And Dr. Matthew Greenberg. I think I just saw him coming on. Dr. Matthew Greenberg.
Present.
And Suzanne Jones, PAC.
I'm here.
Dr. Patricia King.
Present.
Stephanie Lorenz.
Here.
Dr. Ian Odigi.
Yeah.
Dr. Christine Payne. Dawn Philibert.
I'm here.
Judy Scott.
Here.
Dr. Margaret Tando.
Here.
Dr. Robert Tortolani.
Here.
Scott Tucker.
Here.
Megan Campbell.
Here.
Kurt Keel.
Present.
Bill Reynolds.
Here.
Justin Cheng.
Here.
Scott Frenier.
I'm here.
Tracy Hayes. Expect her to be absent. Myself. Paula Nenninger.
Here.
And the last, our newest employee, Ron Hunt.
Hi, everybody.
Hi. Welcome.
And do we have any guests on the line who would be willing to identify themselves? Okay, and we also, I know we have Lauren Lehman has been invited. Lauren, are you on? This is for those of you who knew David Englander, the former general counsel. Lauren Lehman is the new general counsel with the Vermont Department of Health. And she previously was general counsel at the Office of Professional Regulation, is very knowledgeable in professional regulation and healthcare matters. And we're very lucky to have her now with the Department of Health. And she was joining today to become more familiar with the board.
Welcome.
Thank you all. I look forward to working with you and listening in today. Thanks so much.
Great. Welcome to Ron. If all of you have not met Ron, he's going to be joining us in placing Jane's position, and we're all very happy to have him here. And welcome all. Is there any other public comment at this time? Hearing none, we can move on to the approval of the minutes of the June 5th board meeting. And if you've all had a chance to review those minutes, I'll entertain a motion to approve those.
So moved, Lorenz.
Can I get a second?
Second, Philibert.
Great. Any discussion? All those in favor, please say aye.
Aye.
Any opposed? Abstentions or recusals? Great. I do not have any board issues to discuss, so there's no items on that. There's no items on that particular agenda item. David, do you have an administrative update?
I do, and I'll take your time. Sorry,
Great.
got a few items to go over today. First is welcome to Ron, and yeah, we're really excited to have Ron on. The members of South met him. He came, joined us for the South in-person meeting a couple weeks ago, and we're thrilled to have him. He's taken over in the job that Jane formerly held, and he's got a lot of great experience, several years working in the UVM health organization, has experience as a practice manager there. And so we're very lucky to have him. Ron, please introduce yourself to everybody. And
Yeah, pleasure to be here. It's only my second week, and already I'm seeing ways that I can help contribute and support the team. So looking forward to the future.
okay, thanks. And I'll appreciate any input from our clinician members. If tell me if what the warning signs are for inundating him with too much new stuff too quickly. I'm afraid we may be drowning him. All right, the next item, I need to note that we are recording this meeting, and this is because we have a new public meeting law requirement to do so. And all of our meetings from here on out, even when we're meeting in person, and we don't anticipate any members needing a remote option. We're going to have to have everything set up and record the meeting, and we're going to be required to post those recordings for a 30-day period when we first post the minutes, and then we'll be able to take them down. They take up a lot of data space, I guess, and so that's going to be a new thing, and we're all going to be recorded with everything we say in these meetings. And so I am going to, let me see, we're recording this now, right, Ron? We
Yes.
already have it going. Okay, and just a couple things to note. We have the new application options for telehealth registration and telehealth licensure for MD, DPM, and PA have all been added to the our online portal that applicants use to submit their applications. And I just wanted to say publicly, she's not here, but thank you to Tracy for all her work on this. It's really been a lot with the 3 different professions. There are 6 new applications that had to be created with 6 different sets of questions, 6 different sets of instructions that vary a little bit for each of those. We had to figure out how each of them would work, and then write it all out and then integrate it into the system. And it's really been an effort, and we had that up in advance of the July 1st deadline, and we'll be offering those from here on out. Next item, I just want to note, and again, thanks to Tracy and other staff who contributed, the LTL season has just been completed. With almost 450 new and renewal licenses being issued in the last few months since the window opened for that. There were over 300 renewals and over 130 newly licensed residents. We'll continue to see LTL applications because we get a lot from Dartmouth when Dartmouth residents are coming over to do rotations. Sometimes they don't do it right at the beginning of the licensing period, but it's been a lot, and I'm not aware of any problems or issues we've had with getting that done. I do just want to take a minute and let you all know that the staff has been under a lot of stress. We've been short of staff. During the period when we were trying to replace Jane, we've been going through recruitment and interviewing both for that job and for the other new admin position that we've been able to create, and we're still working on that. I just mentioned all the work done on the new applications for telehealth, and there's been a lot of ongoing work for Tracy and Kelly and myself, and Ron now has taken over Jane's responsibilities on the IT project. And that's a lot of work, but important for us, and we're happy to be working on that. We've also had Tracy on her planned time off, and some others having some planned time off, and one staff member had a family medical emergency. And I bring all this up just to say to staff and in front of you all, and recognize them and say thank you for the dedication that you've all shown to your work during this time, and always, but especially now. And I'll just acknowledge we sometimes in the last several weeks we haven't gotten things done in the way we usually do, and as quickly as usually happens. And I just want to say thank you to members for bearing with us while we get past this challenging period. I do want to mention that we came out a couple months ago with the email that was styled as the e-blast, and we'll have another one is going to be going out in coming weeks. We have two topics for that already. One is to publish the joint statement on IV hydration to all of our licensees, and that's important to get word out about that. And there's another one I just want to let you all know about before this goes out. Commissioner Levine and I were contacted by an NYU professor and neurologist and neurosurgeon named Adrienne Lewis. And she wanted to talk to us about a scholarly article that she co-authored. And the article was about a working group that she had been part of to develop new revised guidelines for pediatric and adult brain death and death by neurologic criteria. It was a joint project of the American Academy of Neurology, the American Academy of Pediatrics, the Child Neurology Society, and the Society of Critical Care Medicine. And she approached us, and this is important to Vermont practitioners, because under Vermont law, there is a section that talks about determination of death and determining irreversible cessation of brain function and circulatory and respiratory functions. And the law says that a determination of death must be in accordance with accepted medical standards. And Dr. Levine and I looked at this, and it clearly is an authoritative statement about accepted medical standards. And so Dr. Levine and I were asked to endorse the article, which would be a little bit unusual and unnecessary for us to provide such an endorsement, but we agreed that it would be helpful for licensees to know about it. So that's it's important not only for critical care physicians who would be likely to be treating patients who would be looked at for this issue, but for other physicians such as PCPs who may be in the position of counseling family members or other patient representatives about death determination issues. And it is important in the process of identifying patients who are becoming potential donors for organs. And so we're going to be putting out information just about the publishing of that article. It just came out in December of 2023, so you'll be seeing that as well. That's the end of my comments about the e-blast, the new version of that. I also wanted to mention to you all we will be recruiting members for a hearing panel, and charges were issued. Now, it's now been months since the charges were issued, and the parties have been completing a lengthy discovery process, going through depositions and other forms of discovery to complete their understanding of the facts as each party sees them. And this hearing will likely occur at some time in August or September. The case comes out of the South Committee, so it will that means that the South Committee members are not eligible to be on the hearing panel that will be appointed. We will be appointing a panel made up of North and Central members, and we will need at least one MD and at least one public member to participate, and one other either MD or public member, and have a minimum of 3. Once we have the dates established, which the parties will be working on with the hearing officer, George Belcher, we'll send out an email notice looking for volunteers, and the panel will be assisted by the hearing officer, George Belcher, and they will hear the evidence and make findings of fact, conclusions of law, and recommendations to the board for acting on their charges. I don't know exactly how long that would take. I mean, I could estimate that it will probably take more than a day. Could be 2 days, maybe 3 days, possibly more. Typically, these matters are not scheduled all in consecutive days. There's often, based upon an estimate of the parties working with the hearing officer, they may suggest scheduling 2 days. And then if it's not completed in those 2 days, then they would schedule an additional day in the coming days or weeks after that. So I ask everybody to, for those of you who are eligible to be on the panel, to consider volunteering and be on the lookout for that email. And the last thing is, I'll just note that we do have an item that was added at the last minute yesterday. We have a motion for summary suspension of a licensee, and that will be beginning at 1 p.m. We'll be joined by the hearing officer, and we will move on to that. So that's it for the administrative update.
Great. Any questions for David?
I have a question, Rick.
Go ahead.
Yeah. David, you're looking for non-South volunteers for the panel. I wondered where our PA and podiatry members stand on being members of the panel.
They are eligible and normally I would encourage them to consider being on the panel as well, but our PA and our podiatrist at this time both happen to be from South, so they're not eligible.
Great. Okay. Thank you very much for that answer. Appreciate it.
All right. Was that David?
No, I was just going to say, if there's no other questions, shall I move on to other business?
Yeah, we're going to skip over the hearing, obviously, as it's not yet 1 o'clock. And in other business, we have a few items there. And the first up is an overview of the symposium around alternative pathways to licensure, or I think the phrase that they wanted to adopt was additional pathways to licensure for foreign trained physicians. So myself and David went to this conference in DC last month, and I can provide you just a brief, set of some of my key takeaways, and David can add as well. I'll be brief though. So as a reminder, this was a symposium where we were talking about foreign trained physicians, or FTPs. This is not about international medical grads. We of course have many international medical grads who are practicing in Vermont and have a pathway to licensure. which involves verifying the education of those international medical grads. And then they would, of course, complete a residency training program in America and apply for licensure. For international medical grads, for those of you who don't remember, a number of years ago, we took up the topic of verification of the medical schools that people hailed from. We historically had used something called the California list, which was a carefully curated list of medical schools we felt were appropriate for, or California felt were appropriate for licensure, and many other states adopt. It was an incredibly onerous process that relied on a lot of man hours, and that practice was stopped by California as a result a number of years ago. And for that reason, the list has become stale. Since that time, we and many other states have relied on the process through the ECFMG. I apologize for the word salad, but the WFME, the World Federation of Medical Education, is an international organization that was, I believe, founded by the WHO a number of years ago, back in the 60s or something. One of the services they provide is to accredit accreditation agencies, national accreditation agencies. So in America, we have an accreditation agency for medical schools and for residency programs. We have one. In some other countries, they have many. And the WFME accredits the accreditation agency, who then accredits the medical schools. So if a medical school is registered with a certain accreditation agency, say in, that's a bad example, Germany, and the WFME accredits that accreditation agency, they would be eligible for licensure in Vermont if they went to a residency program in America. There is not a similar process for residency training programs. So there's no way to evaluate the quality of the residency training programs in foreign countries such that we could really know whether this residency training program is acceptable or not. And that's one of the biggest barriers, frankly, to even considering foreign trained physicians for licensure in America. We heard from a number of individuals, including a panel of 3 different states, where they discussed their approaches. One was Maine, which had developed a program to try and basically onboard folks from foreign countries. They had really, it sounds like, decided to rebuild a residency program in Maine. The bill was passed, but it died on the appropriations table because it was very expensive. The state that probably has done the most work in this is New York State, where they spend an extraordinary amount of time reviewing each applicant and reviewing their residency training program. They take a lot of time doing this, and since the beginning of the year, they were able to, I think, bring in something like 80 physicians, and it took a lot of man hours to do so. For us to realistically, even consider something of this nature, it would require us to have some kind of standard to evaluate candidates. And the WFME did take up this topic at their most recent national meeting, and will be starting to accredit accreditation agencies for residency training programs. So in America, that'd be the ACGME, right? And they could accredit the ACGME, and therefore a residency training program that was accredited by the ACGME would be eligible for WFME certification. There's other steps that are required, but one of the biggest takeaways I got is this isn't really a conversation that's worth having until that process is in place, because we just don't have the resources or bandwidth to really even evaluate residency training programs. Even with that in place, there would need to be a lot of steps to bring someone who is trained in a foreign country into Vermont. But until and unless that process is in place, it would be sort of, I think, not value added. So, one thing that I think we should, or at least my opinion is, our stance should be to our legislature, anyone else who's looking at this particular, bill is, hey, let's wait until the WFME has this process in place. There was a lot of other discussions we had. We had a very interesting conversation from Canada. He was the CEO of the I forget exactly what agency in Canada that was responsible for licensure and bringing in foreign trained physicians. One of the comments which was really jaw dropping was in Canada, 1 in 5 Canadian residents do not have a primary care physician because of lack of access. And this is not just in rural communities, but also in their cities. So they're quite a bit ahead of us in terms of doing this and in terms of bringing in foreign trained physicians to Canada. They have a vetting process for residency training programs. They have an onboarding process to make sure that people are welcomed into the country, and an evaluation of the candidates that over several, I think it's 3 months, to ensure that their training is adequate before they're granted full licensure. Thankfully, we are not even close to that here in Vermont or in America in general. But that's certainly a possible future state if the shortages in physicians and providers is as bleak as is projected, at least by Cicero, which I take everything they say with a huge grain of salt. Anyway, that was some of my takeaways. I don't know, David, and I've already probably talked more than I should have about this, but David, if you have any other comments you wanted to make about the conference.
Yeah, I might just step back and provide a little bit of broad context about it. So FSMB convened this, and they have been instrumental in creating a national commission to try and come up with some common standards and a framework for states to be guided by. And because one of the things that was talked about a lot is how problematic it can be, if individuals go through a process to get licensed in a state, but the states all have their own recipe for how this works. They're going to be stuck in one place, and they're not going to be able to get licensed elsewhere, and it's not going to be in anybody's best interest. And so the purpose of this meeting was, I think I see 2 purposes. One was they wanted to prompt individual boards and the leadership of boards to start thinking about this and thinking about what's important to them, and then come together. And we went through a process during this meeting to try and give some input and guidance to this committee board with regard to what's important to state medical boards as they do their work, and that the commission has representatives from all different aspects of the House of Medicine, board representation. They have ACGME representation, and from the testing world and medical school oversight agencies. And so a lot of different perspectives are represented. And so I think that everybody is hopeful that they will be able to find some paths forward. As Rick mentioned, there's a lot of talk about this being a solution for workforce shortages, and especially in rural underserved areas. But one of the things that was talked about, there were a couple people who very eloquently made the point that that we shouldn't look at this as a solution for workforce shortages in rural areas, that putting these physicians who are in need of mentorship and support into rural areas could be a recipe for disaster, both in terms professionally and personally, as the families move, taking families from other parts of the world and putting them in areas where there's fewer social supports and community to support them may not be ideal. It was also talked about very eloquently by a lot of people who were involved in residency training, that as many of these proposals are feature some kind of a I hate to sound negative. It's not meant to be pejorative, but creating a pseudo residency. They talk about what a challenge it is to train people to be mentors and evaluators for to do their roles, and that's still going to be a problem and a challenge for these novel programs, which will demand resources. So it was really interesting. I think a lot came out of the one-day meeting, and I'm really thankful that there should be more formalized information about this as before we go into the next legislative session, because I expect it is going to be discussed. And just one last comment, as Rick noted, New York has done an unbelievable amount of work on this. It sounds very labor intensive. They've and looking at New York has 100,000 or more licensees. We have roughly 5,000. So just on a proportional basis, them getting 80 additional licensees in a year is like us getting 4 additional licensees. So it's not a big part of a solution to workforce issues, as at least that was the opinion that many had at the meeting. So I didn't have anything more to add. Are there any questions about the symposium?
Don?
Rick, what is Cicero?
Cicero's a think tank that was commissioned under the Trump administration to evaluate the addition of foreign trained physicians into the workforce. There was I talked to one of the board members of FSMB who gave me some insight. The study was commissioned as apparently as a means for cost reduction, a healthcare cost reduction, which anyone who's familiar with healthcare finance is this is a ludicrous solution to reducing healthcare costs, but it has its own bias for sure, and they were
Consider the source.
Right. They were called out directly in the meeting and
Okay.
by a couple of members of the FSMB. But, they had some slides that I think maybe there's some information that could be gleaned from, when they talk about, projections for shortages, they may be accurate. I think their solution was it didn't make any sense in many ways. But anyway, so
Thank you.
Again, lot of huge grain of salt when you interpret anything from that particular think tank.
How do you spell
They had a
Cicero?
representative from Cicero who was a presenter at the symposium.
Thanks. How do you spell Cicero?
Cicero.
Thank you.
Evan?
One question and one comment in addition to thanks for the update. The comment is that Canada's shortage was completely foreseeable, and the shortage that we're facing in the US also is completely foreseeable. The one in the US had to do with deciding basically a generation ago in one of the congressional budgetary processes just not to fund as many residency training slots in the US. In psychiatry, they particularly hit geriatric psychiatry. They just did not fund enough training slots. So it's not that people don't want to be geriatric psychiatrists, it's that they decided not to have enough. And so if anybody is talking with your representatives at any point, a good thing to talk about is funding adequate residency training spots for US grads as part of our solution. I will now get off the soapbox and ask my question, which is that I wondered if there was any talk of looking at this in a specialty specific way, if that came up at all.
So admittedly, the majority of the perceived need and discussion was around primary care, which really is the primary concern, I think, in most jurisdictions around the need. There's other pathways to licensure for super specialists or individuals like transplant surgeons and people who there's just so many in the entire world around, but really the majority of the discussion was around primary care, although I think there was a little bit of discussion around OB as well, which I think in our country is a different particular problem.
Yeah, general surgery is also very short. But why I mention that, and this is probably more granular than we're going to get into, the degree of fit and the degree of extra training that people need is really different, specialty to specialty, to my observation. But we can leave that for another day.
Right, and unfortunately, primary care is probably the one that would be the hardest to translate from one place to another, right? I mean, it's just so nuanced depending on the healthcare system and the community, even the community you're in, right? The states are different.
Psychiatry is also a
Right.
difficulty because of the heavy, it's largely culture referential. And so there's a degree of acculturation when you move from one country to another.
Any other questions on that topic? No? All right. Next up is medical licensing requirement topics in the news. David, you want to take this?
Yes. So I just tried to start sharing my screen. I hope you can all, did that come up, everybody? Are you seeing it? I wanted to take just a couple minutes to there were news reports about this, and I don't know how many of you heard about it. There was recently a presentation to the Green Mountain Care Board and the Agency of Human Services Director of Healthcare Reform, who commissioned a study on, and it essentially was about the challenges to Vermont and a report to be used in a planning process for supporting sustainable access to care. This was directed by Act 167 of 2022. And I gave you a copy of the slide presentation that was used during during the oral presentation of the report. And I also gave you as an example, one news story that had talked about this, and I just wanted to give this to you as an informational item, and that in some ways the board was and other medical regulatory authorities in the state were called out just in and I don't know if you all looked this over, but I'm just going to skip ahead to the part that I'm speaking about. And this is on the fifth slide. There's you can see the slide says that state legislature regulations item on the left, cumbersome licensure requirements. And then later on in the presentation, there's they call out the need to enlarge the workforce and also address the as actions that need to be taking revised licensure for mental health professionals, pharmacists, APRNs, and enhanced local training programs and increased workforce pathways. And finally, it also speaks to licensure streamlining. And some of these, many of them address mental health professions that we don't direct directly control other than psychiatry, obviously, but and it also brings up the topic of scope of practice, talking about allowing pharmacists to extend prescriptions. So, you know, that we may be hearing more about this, and there may be more discussion in the news report that I mentioned, and this is what really kind of brought my attention to it. It was see if I can find the quote. Some of the recommendations, and this is a news report or summary, some of the recommendations dealt with regulations around care providers. Pharmacists should be allowed to dispense more medication refills, and Vermont should simplify its licensure regulations to make it easier for trained practitioners from other states or countries to practice. Again, I wanted to make you aware of this. It does relate to our work. It relates back again to what we were just talking about, the symposium about additional pathways for foreign trained physicians to be able to come in, and with this is going to be on the mind of the legislators and advocates who are part of those discussions. And we are likely going to be asked to weigh in on different proposals during the coming session about scope of practice and licensing. And finally, I just want to say it highlights the importance of the work that many of you did on our license process review that took place last fall. And we have implemented a number of the changes that were directed, and I've completed a redraft of the rules to make the changes with regard to references and the process for identifying applicants and those who are about to go into the formal rule revision process. And again, this is in the news, and I just wanted to bring it to your attention how many different ways this affects us, and the things that we're doing to already to reduce the whatever unnecessary burdens or delays there may be in our licensing process. So that's all I had on the topic, unless there are any questions from members.
Gail?
Yeah, I was just wondering, putting together Dr. Eiley's comments with your comments, is there some study comparing the costs of creating more residency slots and increasing the supply of practitioners locally trained with putting in these new systems for checking out foreign graduates? It seems
I'm
like
not
it would
aware of
almost
any.
be
I'm not aware of any such study, and it's
a little too late, unfortunately. So, you know, the order of magnitude we're talking is something like 10,000 licensees in a matter of, you know, months. Something like 10,000 additional licensees a year. It's just not a scope that we could address quickly. I think when you talk about solutions to shortages, there's multiple different pathways. Increasing the amount of residency training slots is a big part of it, but that's really to address concerns 10 years from now. It's not going to affect the problems we're facing today, right?
I think, Gail, it also, your question, you know, just going back to the last topic a little bit more, it points out that there are a lot of different variations. There's not, we're not talking about one type of new candidate to become a doctor in the United States. There's the refugee community has been active in this, and you know, this isn't just about filling filling physician roles is pressure from individuals who want to get licensed here, who are trained and practiced in other countries, and who are saying, why isn't that good enough? And just generally other, physicians who work in other countries and have taken boards there and have completed whatever kind of training is required there, whether it's a formal residency program or an apprenticeship, and practice there successfully. And they're saying, why can't I get licensed there? And so there are, there are a lot of nuances involved in this. And we will be hearing from all those different groups that are interested in this.
Thank you.
Pat?
You're muted, Pat.
I just had a question about the commissioner work group for the naturopaths on filling out the COLST and a DNR and whatnot. And did that come out of this commission? Or is it related or unrelated?
Oh, no, that's a
Oliver
separate.
Wyman thing? No.
That's
Okay,
this
that's a
is
separate, okay.
And that's
Thank you.
that's the next item. Are
Yeah,
there any,
great.
before we move on, are there any more questions on?
Dr. Kader.
I just wanted to address Gail's question about residencies. I am aware of a primary care residency program in development, which is a cooperative effort among the federally qualified health centers in different areas of the state. And my understanding is that the development process is going on right now. I believe they hope to start taking residents in 2026. And this would be for family practice.
I'm aware of those efforts. I am less optimistic that this will come to fruition in any time frame, but we'll see. It's been done in many other states. It requires a lot of support from folks outside of the FQHC, so we have to see how that's going to work. But I am aware of that as well, and we'll see how it goes. The only comment I had about the topic we were just discussing on the report from Oliver Wyman to the Green Mountain Care Board. So as David had mentioned, we did a lot of work to address a lot of the issues that we had self-identified, but also were tasked to look at by the legislature. So I feel confident in responding to any inquiries about this. Although I got to admit, part of me would really love for the Green Mountain Care Board to come to us and ask us about our cumbersome process. I would just love to hear that from the Green Mountain Care Board, because if anyone's a little cumbersome, it's them. Anyway, I think Evan.
Yeah, other states have tried the put a family medicine residency program in an area of need and have found that to be quite a successful model. As Pat has pointed out in the chat, many graduating residents stay in the state where they train, and a family medicine resident is only 3 years, and there are currently medical students trained in the US who are not getting residencies. There are not enough residency spots for the graduating students. So it's one of those things. I think that one of the reasons this doesn't come up more is that it requires getting federal funding to do it. And people tend to regard, particularly Congress, as sort of intransigent and unresponsive on this issue. And I just think, when these things come up, it's an opportunity to challenge that thinking and say, there's a supply chain that we could access. There's a proven model. What it would need would be some dollars.
Hey, any other comments on on that? We have 9 minutes left until the hearing starts, and I think we can get through this last one pretty quickly.
Okay.
So Act 158 of earlier this year called on the commissioner to convene a work group to consider the integration of naturopaths into the processes. And we had talked about this a little bit during the session, and rather than acting on it, they asked for the Commissioner of Health to lead a discussion about having naturopaths involved with patient choice and the life, DNR orders, advanced directives, and calls. So as they are preparing for that process, and we didn't get assigned a seat at the table, and I think that was a good thing. We've got a lot on our plate, and we'll be able to provide input to the health department. And your thoughts on this can be part of that process, and we can talk about that at future meetings. But right now, they wanted to know, as the staff of the health department is preparing to support that process, they want to start doing the work to gather information that this group would want to see. And they said, what would somebody on that group want to have? I provided in the agenda, I provided 3 bullet points, not to steal your thunder, but just to make this a little bit more efficient, things that I thought were pretty obvious. That you would want to have information about each of the processes and the factors considered in each process and the role of the clinician in those different processes. Facts about the facts about the education and training of allopathic, osteopathic, and naturopathic physicians, so that any differences in the education and training could be considered. And also, perhaps, to what extent are naturopaths involved in these processes in other states? And I said that I would put it out to board members and see, does anybody have any thoughts about other information? If you were participating in that work group, what other kinds of information might be helpful for that group to consider when making a decision about should naturopaths be added to the statutorily authorized provider roles that right now does not include them.
I would just one other layer on the educational training of naturopathic physicians. So assuming there's a gap there, is there training available that could be available to naturopathic physicians prior to being able to do some of this paperwork and documentation? I imagine they'll find significant gaps, and if their desire is to continue to support going down this path, is there a way to provide education to these individuals? Pat?
Yeah, I would agree with Rick, and just also have us or have the commission think about the complications and the pitfalls of the processes, and maybe what fundamental education is best prepare someone to best serve the patients in these processes as well.
Okay, so I would make those 2 additions, and you all thought that the 3 that were on the agenda were sound things to bring up too. Yeah. All right, well, I will share that with the staff, and I think that we've met the goal of concluding other business before the hearing process. Or I shouldn't say hearing, it's a hearing like, and so I asked George Belcher to join us and to lead this part of the hearing. And we are going to have a presentation about a matter that you're going to be asked to act on, but it's not technically a hearing.
Okay. Welcome, George. Why don't we move on to that item?
All right. Can you hear me all right?
Yes, we can.
Good, thank you. So, good afternoon, everyone. My name is George Belcher. I'm a hearing officer for the board. This afternoon, we're taking up a case of Inri Tanya Sarkaria. The docket numbers are MPS 175-0823 and MPS 0670424. Megan Campbell is representing the state. William Smart is representing the respondent. And I see the respondent. I see your picture, Dr. Sarkaria. Good afternoon and welcome. Because this is coming from the South Committee and I wasn't here when the meeting started, I'm going to call the roll. If you're on the South Committee, please tell me that. And if you need to recuse or abstain, please say that when I call your name. Mr. Ciapinelli?
Present.
Dr. Kader?
Here.
Dr. Eiler?
Present.
Ms. Falk?
Present.
Dr. Gades?
Present.
Dr. Greenberg?
Present.
Dr. Hildebrandt?
I am here, but I'm on the South Committee.
You're on the South Committee? Thank you.
Yep.
Ms. Jones?
I'm here and I'm on the South Committee.
All right, thank you. Dr. King?
Present.
Ms. Lorenz?
Present, and I'm on the,
I understand that you're on the South Committee, is that right?
yes, that's correct.
All right, thank you. Dr. Odegill?
Present, and I'm on the South Committee.
All right, thank you. Ms. Philibert?
I'm present.
Ms. Scott?
Present.
Dr. Tando?
Present.
Dr. Tortolani?
I'm present and I'm on the South Committee.
And Mr. Tucker?
I'm present. I'm on the South.
All right, thank you. So those members that are on the South Committee can listen, certainly, but you won't be participating in the decision. You won't be voting on it. And if there's a deliberative session, you won't be entering that. I think the board members should have the following documents that have been provided to you, and we'll go over some of that. There's a motion for summary suspension that was filed by the state. There's an objection, the licensee's objection to the motion. You should have a copy of that. And then, Ms. Campbell, was there an affidavit or affidavits that have been prepared here?
Yes, they have been prepared, and I have received confirmation by email from Attorney Smart that there is no objection to the redactions that have been made to the two affidavits that were submitted.
So when will the board members see those?
I would seek clarification from David or board staff about what procedure the board would like to follow to distribute those affidavits to the board members. Because of the redactions, they were just very recently provided to board staff.
We could have those emailed out to the members of Central and North. Would that be appropriate to limit it to the members who are considering the matter?
Yes.
And we can do that in the next several minutes.
All right.
Thank you.
Thank you. That's great. And David, do you have those already? Is that right?
I don't know if I've gotten those. I haven't been on email while in the meeting, but let me see.
So I just want to make this statement for the board. clearly the material that's already been provided is somewhat lengthy. And these affidavits are necessary to complete the picture that is being presented to you today. And what we'll do is Mr. Hurley, he will send those out. If you can check your email and download them so that you can refer to these affidavits as we go forward. But what we're going to do is we're going to go forward. There's some other things that we can be doing while that process is happening. So this matter is a request for summary suspension. Since I've been working with the board, we haven't done one of these. They're somewhat unusual, and I thought it would be helpful for the board members to have some idea as to the ground rules concerning a request for summary suspension. And I'm going to refer to the statute. Actually, the statute was repeated on the motion on page 9. But the general rule is that doctors and respondents are not disciplined or have their license put in jeopardy unless there's a hearing with due process. Section 814C of the Vermont Administrative Procedure Act says, no revocation, suspension, annulment, or withdrawal of any license is lawful unless prior to the institution of agency proceedings, the agency gave notice by mail to the licensee of facts or conduct which warrant the intended action, and the licensee was given an opportunity to show compliance with all lawful requirements for the retention of the license. And then this is the somewhat exception. If the agency finds that public health, safety, or welfare imperatively requires emergency action and incorporates a finding to that effect in its order, summary suspension of a license may be ordered pending proceedings for revocation or other action. These proceedings shall be promptly instituted and determined. So that's a quote from the statute that is on page 9 in the footnote. In addition, the board has a rule dealing with summary suspensions, and this is important because the language is pertinent. The rule 44.1 says, summary suspension. The investigative committee may find that certain alleged misconduct poses so grave a threat to the public's health, safety, and welfare that emergency action must be taken. In such a case, the committee will request a special meeting of the hearing panel and recommend that the board order summary suspension of the respondent's license or certification pending a hearing under the authority of 3 VSA section 814C. That's the one I just read. If the board orders summary suspension, a hearing will be scheduled as soon as practical, and the Assistant Attorney General will present the case against the suspended professional. So just to describe that a little more, if a summary suspension is granted, number one, a party can ask to have that reviewed with a full evidentiary hearing as to whether it was justified or not. That's one review. And then if a summary suspension is approved or denied, there can be a full-blown case seeking discipline against a professional for unprofessional conduct. Those are the sorts of cases that you folks deal with regularly. So if a summary suspension is granted, there's an opportunity for a fairly prompt review. And if it's granted, a full-blown case would probably follow. If it's denied, there would be no need for a review, and there could still be a proceeding seeking professional discipline. Another housekeeping matter, in the licensee's objection, there was an Exhibit A, and often pleadings attach exhibits. But in the context of today's proceeding, I want the board members considering this to understand, even though Exhibit A was not attached, it's not an item of evidence. It did not go through the usual evidentiary screening of authentication and verification. It wasn't subject to pertinent questions surrounding it. And so while you've seen it, if you've looked at this, and we're not going to ask that you unsee it, but at the same time, you have to consider that it was not produced in evidence. It's not admitted into evidence. And then finally, the process that we're going to follow today. The state is going to make a statement and an argument in support of the request, which came from the South Committee to grant the summary suspension, and explain the motion. And board members at the conclusion of that can inquire of Ms. Campbell as to if they have questions. Following that, Mr. Smart will be able to address his client's side of this and make argument on his objection to the motion for summary suspension. I would caution board members, while you will each be able to inquire of counsel, two cautionary points. Number one, this is not an evidentiary hearing. So if you ask them a question that calls for evidence, that's somewhat out of bounds today. They can address what the allegations are and what the factual basis they think they have for those allegations. But if you ask them what proof they have, that remains for another day. The second thing is that this case involves a guardianship matter for an alleged disabled adult. And given the small community that we live and work in, we're trying to protect patient confidentiality and patient records. So if you ask a question that calls for identifying information, that will probably be a problem. I've spoken too long and I want to stop talking. Are there any questions for me before we get started? All right. Thank you. Ms. Campbell, if you're ready, go ahead.
Thank you. This involves a motion that is brought to you at the behest of the South Investigative Committee for summary suspension, which is outlined below, is calling for a summary suspension of respondent Tanya K. Sarkaria, MD's license on an emergency basis because of the factual allegations, which I will outline here. Tanya K. Sarkaria, MD, holds a Vermont medical license, and she has done so since October 7th of 2020. The state's basis for jurisdiction in this matter is outlined in the state's motion in paragraph 2. Respondent is a psychiatrist who has a specialty in child and adolescent psychiatry. She is currently in private practice. She represents that she serves vulnerable populations currently at Brookhaven, which is a residential treatment facility for children, as well as Community House in Brattleboro. And that is pertinent to this motion because these allegations involve vulnerable patients. This summary suspension is based on two separate investigations. I am going to start today by addressing the second of those investigations, which is also the most proximate to the filing for summary suspension in this matter. The board opened an investigation on its own initiative into respondents' practice in April of this year, after receiving information from another state agency that there was medical documentation of concern involving the respondent. The records from that agency were obtained by the South Investigative Committee. They involve a request for 10 patient charts, and it's important to note here that full patient charts were requested of the respondent in this matter pursuant to that other agency's legal authority. Upon review of the documentation which was presented, the South Investigative Committee had significant concerns for the practice that was detailed within those records. And I'm going to talk about some of the issues that were noted from that review of those 10 patient records. I'm going to start by referencing an individual who is referenced in this motion as patient 2. Patient 2 was 17 years old at the time of treatment. Patient 2 was an extremely vulnerable patient. Patient 2 had a history of self-harm. This included suicidality and a suicide attempt in the past. This was a patient who had a history as a runaway, a history of depression, and 3 days before Dr. Sarkaria's first appointment where she billed for treatment, this patient had had a medical event where she had self-harmed with both medication and a razor. The respondent did not produce any clinical records for this patient. That means that there were no medical records of her treatment of this patient, no patient medical history, no family history, no information about her symptoms, justification for prescriptions, no information about proper dosing, and no information about how the patient reacted to medication or other medications this patient may have been imbibing, prescribed or unprescribed. During the period of time that she treated this patient, which was approximately 4 times from January 2022 to April 2022, she prescribed lorazepam and Vyvanse for patient 2. When the South Investigative Committee looked further into her prescriptions for this patient, they discovered that respondent had never registered with the Vermont Prescription Monitoring System in Vermont, which is a legal requirement for patient safety. Because she had never registered, she had also not done the mandated legal querying of that database to make sure that the patient wasn't prescribed other substances at the time that she was prescribing a benzodiazepine. Similarly, the committee found that respondent had been prescribing for a 13-year-old who suffered from anxiety. She had billed Medicaid 8 times during her course of treatment for this patient from approximately July of 2021 to January of 2022. The medications this patient was on included Concerta, Focalin, and Adderall, all Schedule II controlled substances. Again, there were no medical records for this 13-year-old patient for whom she was prescribing. And we know that she was not using VPMS for this patient because she was not registered. In addition, um, the motion outlines concerns for another patient who's listed on page 8 of the motion as patient 4. This is a patient who is 19 years old at the time of treatment. And this is a patient who she treated for a period of 2 years. Billing records indicate that she has provided treatment to patient 4 times this year, yet she was unable to produce medical records of her treatment this year. Present throughout the records that were reviewed by the committee, but exemplified in this patient's records are concerns with the medical documentation that was provided for appointments with patients. One example of this is a medical record which is dated in the spring of 2021. And it lists that the patient was last seen 2 years later. So 2 years after this medical record was created. It then in the same record indicates that the patient was seen in June of 2022. This is detailed on page 9 of the state's motion. The respondent's electronic signature on the record is dated March 5th of 2023. Concerns like this are present in a significant number of records for this patient, and they include concerns such as a note from May of 2022, which lists crisis stabilization that was provided 5 months after the appointment being recorded. In addition, there are notes from June of 2023 that are listed as signed by respondent a year earlier. These gave the South Investigative Committee significant concerns for the accuracy of the records that were being provided to it as a record of the clinical treatment that respondent was providing. In addition to the concerns from that investigation, which is listed as MPS 0670424 in the motion, the committee also had a prior investigation involving the respondent, where they had additional concerns for her treatment of a vulnerable adult. This case was opened on July 10th of 2023 after the board received a complaint from the parents of a former patient of respondents who was referred to in this motion as patient 1. The complainants here informed the board's investigator that they had been patient 1's guardians through probate court since February 3rd of 2020. Patient 1 is an adult with developmental disabilities and a very complex medical history, which involves psychiatric hospitalizations. The complainants provided guardianship paperwork to the board, which verified that they had a full guardianship through the probate court for this patient, which included medical decision-making. That guardianship remains in effect. The complainants alleged that respondent ended treatment for patient 1 abruptly on October 26th of 2022. It is important to note here that at the time this treatment was ended for this vulnerable patient, the patient was at the Brattleboro retreat and suicidal. Days after treatment ended for this patient, the patient's parents made the first request to Dr. Sarkaria that she transfer this vulnerable patient's records who was in psychiatric distress to the patient's current primary care provider. The complainants included a copy of this communication to the board. Dr. Sarkaria did not respond in any way to this communication for continuity of care for this patient in distress for 11 months. And that was after a board investigation had been initiated into this matter. When the board investigation was initiated, she initially asked again for the guardianship paperwork and said that she needed a release of information before she would release the records. She, in subsequent communications, changed that request to say that she needed to consult with her attorney, and then she asked for a signed release from patient 1 directly. This was provided to her on November 10th of 2023. She, in her communication to the South Investigative Committee, several days later on November 14th, 2023, said, by virtue of the November 10th, 2023 authorized, signed by patient 1, I am now comfortable that I have been authorized to release patient 1's medical records to her primary care provider and will do so. This did not occur until the middle of May of 2024, despite her representation to the board, and the May records were sent only after her counsel was informed that the medical records had not yet been sent for this vulnerable patient to ensure continuity of care. During this time, she was interviewed by the board's investigator, Scott Frenier. She was provided with an opening letter at this interview, and before he could ask her any questions, she admitted that she had been double billing for care and would pay that money back. She then went on to explain that she did not think the complainants had a valid guardianship for patient number 1. During this time period, the respondent began to engage in a period of conduct towards the complainants that was retaliatory for their filing of a board complaint. These communications were often hostile in tone, and they made suggestions such as that the complainants had neglected their adult child, indicating that their adult child's low adaptive functioning was a result of the parenting she had received and their decision to homeschool their child. They contained threats of using legal processes against them in retaliation for the complaint that they had made to the board that was under investigation. These communications are recorded in the state's motion beginning on page 4. I'm going to read them for you. I also encourage you to follow along because they're in some ways easier to read than to listen to. Before I start reading them, I am going to briefly take a segue to tell you that When the board requested records from respondent, which it did by subpoena on January 23rd of 2024, it requested a copy of all communications with the complainants. There was a record production by the respondent on February 9th, 2024, which included an authorization, a certificate of authenticity as the records custodian that she had provided responsive records. She did not produce any of the materials I am about to read to you in that February disclosure. She was later informed, or her counsel was later informed, that she had not been forthcoming with all communications, and a portion of those communications were produced this May by her counsel. The full communications with the complainants have never been produced by respondent. We have them because the same records were requested from the complainants. Among the material which is of concern in those communications are the following, starting on page 4. My lawyer will be responding to the complaint to the Vermont board. Outside of that, I will be taking legal action on my own, including writing to the district attorney. My previous adult protection report was not accounted for. Next on page 5, I must report that any retaliation from complainants be responded with a protection restraining order for falsely representing as guardian managing mental health care for an individual without legal stimulation to prove competence or capacity of patient. The next one. Patient 1 deserves autonomy, adequate separation from parent figures to be an individual. Most importantly, basic civil and human rights. How dare you? This situation is everything I stand against as a child psychiatrist. Not okay. Our email chain will be presented to my lawyer and the Vermont Medical Board. Other healthcare workers worked really hard every day to support our communities. How dare you point a finger without looking at your own discrepancies? Overtly illegal representation. Next, she communicated, you questioned my license, my source of livelihood, to obscure your role and reality in patient 1's care. I will be following up, taking legal action, harassment and discrimination. Next, I called PCP and left a message and she didn't call me back. I'm not sure if PCP has the authority to call me back. It's a good question. Why didn't any doctor call me? Did you not allow it? That's another example of obstructing care. I believe this is a case of neglect and Munchausen by proxy. I will be advocating for patient 1. It's too complicated and I'm way too invested in this to let it go. Let's play. Next communication. These are all electronic records. I'm a specialist in my field and I don't need you to tell me how to practice psychiatry. Classic case of Munchausen's by proxy. I'm glad everyone will be able to see it. I want to note here that this wasn't a continuous dialogue between the complainants and respondent. Many of these messages were sent within a very short time period without any response from the complainants by the respondent to them. In addition to sending those communications to the complainants, and I want to remind the board that it is against board rules to retaliate against witnesses in board investigations. Respondent contacted patient 1 directly by email on November 9th, 2023. We have no indication in any records that respondent has provided that she had any knowledge or continuing relationship with patient 1 in the year since she had chosen to end her care. This means that during that time, the last contact that respondent had had with this patient. The patient was hospitalized and suicidal. The respondent wrote to her, "Your parents do not have the right to make medical or psychiatric decisions for you. You have a basic guardianship, only to help with housing, finance, etc. Voluntary guardians, capitalized, do not have the right to make mental health psychiatric decisions." At the time, she, in addition to this communication with the patient, also told the complainants that she was going to independently contact the patient's current providers to inform them of, quote, the accurate guardianship status, unquote. She was informed in writing by the complainants that she did not have permission from the patient to do this. She still maintained that she would contact the providers, and the information we have is that she did so. In addition, because of her comment to the board's investigator that she had been double billing, when the investigative committee requested her medical records, they also requested her billing records. When they did so, they found 6 states for which she produced no corresponding medical records. And with respect to these medical records, in response to communications from her counsel that she had in fact provided them, the investigator went back through and checked her billing codes with a coder to verify that the documentation that was missing was substantial documentation for the codes that she was billing. It's also important to note that, as I said before, her records were subpoenaed in January of this year. She just produced medical records that have never been produced before this week in preparation for this hearing. So these are records that the South Investigative Committee has not yet had time to review from a provider with concerns about the authenticity of her medical documentation. And those are the records that encompass Exhibit A here today, which the hearing officer was describing previously. So those are records that were subpoenaed in January and not produced in February with other medical records. In addition, there was communication to her counsel in May that if she had not produced all records, she had a duty to hold her records in an organized fashion and should produce them immediately with a rationale for any late filing. And that was an additional communication in May. Given all of the conduct that I have outlined here for you today, the South investigative community had substantial concerns about respondents' ability to safely treat patients in the community while their investigation remains pending. The contention here today is that this level of practice is unsafe, and we have evidence it is ongoing. As outlined here today, she produced no records whatsoever for vulnerable patients. She did not query VPMS as required for their safety, or even register as required by law. When she did produce records, there were multiple inaccuracies, including records that were signed years after the treatment described in them, or records signed before the treatment described in them occurred. When the parents of a patient with developmental disabilities who had been hospitalized for suicidality asked her to send the patient's PCP her records, she didn't respond in any fashion to them for a period of 11 months. When she did respond, she suggested that their child's functional deficits were their fault. She accused them of having Munchausen's by proxy, and she indicated she was glad it would be publicly exposed. She threatened them with legal process for filing a complaint to the board. She did not produce any of these abusive communications upon her first record production to the board, and to date has only produced a portion of them. She interfered with the guardianship of a vulnerable adult. She wrote the vulnerable adult, who she had had no contact with, for her own records in a year, and who at the time of the last treatment had been hospitalized for suicidality. And she suggested that to the vulnerable adult that her parents did not have medical decision-making authority under that guardianship, which by law they did have. She also disregarded her patient's wish not to contact the patient's present providers. Meanwhile, she continued to not provide the patient's medical records to the patient's PCP. The records were ultimately not produced for a period of 18 months. It's unclear whether the records that were just produced to you today have ever been provided to the patient's PCP. These problems continue to the present day with the recent record submission made in preparation for this hearing. She made a partial disclosure of a portion of her communications to the complainants in May, after her counsel knew there were treatment records missing. But these records had initially been subpoenaed in January. For all of these reasons, the South Investigative Committee concluded that this was not a practitioner who could safely practice and provide care for a vulnerable population while this investigation was ongoing. I am here at their behest to request a summary suspension from the board. Thank you.
Are there any board member questions of Ms. Campbell? All right, Mr. Smart, if you want to,
George, I
was
think
there a
Matt-
question, Dr. Eiler? No?
Sorry,
No,
sorry,
I
Judge.
didn't hand up.
Oh,
This is
I'm
Dr.
sorry. Dr. Greenberg, go ahead.
Sorry, I just had one brief question, and that was, there was mention of an APS report in the complainant's statement. Was there an APS report placed at any point in time?
She asserts there was. We have no information that it was accepted for investigation. In fact, we have information from the complainants that it was never accepted for investigation.
Thank you.
Any other board member questions? All right, go ahead, Mr. Smart.
Well, thank you very much. Just to sort of pick up where we left off, there was an APS report made on October 27th of 2022, which was shortly after Dr. Sarkaria terminated the physician-patient relationship with patient one. My understanding is that was not, it may not have been accepted or acted upon, but it was a report that she made in good faith long before there were any complaints by patient one's guardians to the board. Members of the board, my name is Bill Smart. I'm a Vermont licensed attorney at Morrison Mahoney LLP. I took on Dr. Sarkaria's case just a couple weeks ago, and it's my pleasure to be here today on her behalf. Now, there are a lot of allegations and facts in the state's motion that we disagree with, and we have a limited ability today to rebut them. There's no opportunity today to call witnesses or submit evidence unfortunately. But I do think the one thing we can all agree on is that it is the board's paramount duty to protect patients and the public. And that is never more true than on a motion for summary suspension. To be clear, the issue for today is not merely whether there might be grounds for professional discipline, but rather whether Dr. Sakaria presents such a danger to her patients and the public that emergency action is warranted prior to a full and complete vetting and presentation of the facts. Based on the state's evidence, I would respectfully submit that the answer to that question is no. Dr. Sakaria is a fellowship-trained child and adolescent psychiatrist. She did her fellowship up at Dartmouth and entered private practice as a solo practitioner, primarily in Vermont during COVID in October of 2020, which was certainly a challenging time for all of us. Since that time, she has not been the subject of any discipline and has not had any prior or subsequent complaints to the board. Patient one submitted their complaint back in July of 2023. So it was on July 10th, 2023. So it's a year-old complaint at this point. And it's really about the failure to produce medical records based on a misunderstanding about the scope of their guardianship and whether they had a right to those records. And of course, in a context where Dr. Sakaria had legitimate or at least good faith concerns about whether they were acting in the best interests of her patient. The complaint has nothing to do with her medical care, nor is there any allegation that patient one or anyone else has been harmed. On the contrary, Dr. Sakaria, she's currently working with a panel of about 35 patients and families who appear satisfied with their care and are probably not going to understand why they need to find another doctor over the holiday weekend based on these allegations. The state's evidence includes some argumentative emails that were exchanged last fall, not with the patient herself, but with her guardians. Clearly, if Dr. Sakaria could do that again, she would not have sent those. If she had consulted with myself or some other lawyer at the time, she probably would have been advised not to engage with them. But I think it's also important to keep in mind that being the subject of an investigation is very unnerving and stressful. The emails, they don't include any profanity. They don't include any threats of physical violence, God forbid. And they really shouldn't reflect on how she's communicating with other patients. It's clear, I would submit, that while the emails are a little frantic and were admittedly all sent within a very short time period, they seem to come from a place of concern for her patient and not as a retaliation for a board complaint, especially when you consider that she had made that Adult Protective Services complaint almost a year prior. Dr. Sakaria reports that she is currently registered and querying the Vermont drug monitoring database, and she's also working to enable a function in her EMR that was going to query her to do that and allow her to do that, through the EMR. So she's certainly doing that now. It may warrant discipline that she wasn't registered for that. When she got out of her fellowship in New Hampshire, she really wasn't using that database within the fellowship or in her residency, which was in Minnesota. She goes into private practice in Vermont. She should have known to register for that and to query, and she didn't. And maybe that warrants discipline, but I would submit that it doesn't warrant a suspension of her license, let alone on an emergency basis. She reports that she's in a much better place currently to manage her billing and documentation. There was a time when she first went into private solo practice that she outsourced her billing to vendors who did not perform as promised. There's no doubt that there are errors in the billing records, which are then being matched up to records by the state in order to infer that there are more missing records, quote unquote, than is true. And these allegations, they haven't been fully vetted yet. Dr. Sikaria has not had an opportunity to respond to the second opening letter concerning these allegedly missing records and billing issues. Her response is actually due a week from today on July 10th. I would submit that there's no reason not to wait for that and allow her to be heard on that. I would submit that it can be difficult at times, and perhaps more difficult. Maybe some of the providers here today would understand this, that the EMRs, they're set up in a very user-friendly way for a provider when they're navigating it for their patients, but it sometimes gets more complicated when you have to export records. There's no sort of print all or export all records button, and Dr. Sikaria doesn't have, a staff that is able to help her do that. So there's certainly opportunity for confusion when responding to requests about her billing from Vermont Medicaid, which she did. There was a subpoena served by the board for records in February. It was initially served directly on her when it probably should have been served on her former counsel. She started responding sort of piecemeal to that request directly to Investigator Frenier. And then later, ultimately, her former counsel produced records to the board. So there's certainly some confusion and inconsistencies in the record. And she acknowledges that at times she's fallen behind on records, and at times she's dictated records that don't get uploaded from Dragon to her EMR. And perhaps that's grounds for discipline, but it's not grounds for a suspension of this provider's license, certainly not on a summary basis. And she's in a much better position now with a smaller panel of 35 patients to manage these issues. She finally understands how to do the billing things herself, and feels confident that she can provide good care and is providing good care to her current patients. I wish we had the opportunity to bring folks in to provide testimony on that, but we don't today. And so, I would submit that the state, they're kind of arguing that the whole is greater than the sum of the parts here. But when you look at what's being alleged on an individual basis, it's about practice management, records, billing, confusion on Dr. Sikaria's part over the scope of a guardianship. And in her defense, she was never, until within the last couple of weeks, provided with the actual pages of the guardianship paperwork that delineate what the guardian's powers actually are. So there's a single page that just says they're the guardian, and there's another couple pages that actually check boxes for what they're entitled to do, and she was never provided with that. So we're looking for an opportunity for her to keep her license while these issues are further investigated and sorted out, so that she can come and be heard at a hearing. And again, I think when you look at what's being alleged here, none of it adds up to an emergency suspension, which obviously is a tremendous power that the board has. And it's not something to be exercised lightly. And on that basis, we'd respectfully request that you deny the state's motion.
Are there board member questions for Mr. Smart?
I have a question.
Go ahead.
You mentioned a couple of times that Dr. Sakaria is now in a much better place than she was when these situations occurred. Can you delineate for us how that has changed, how it's different now from what it was before?
I can, and I can do that because she just sent me an email before we came on with some points on that. So, I mean, number one, I mean, she's registered with VPMD, and she is regularly querying that through the internet for prescriptions where it's required. Again, she's working on a plug-in with her EMR system that's going to facilitate that, and is probably what a lot of other providers and with better resources have been using. Right, she started to manage her own billing in 2023, and there was a big learning curve on that. But she's gotten lessons and consultations with billing experts at Advanced MD, so she feels more confident in her documentation of the billing. You know, she takes responsibility for, you know, not effectively managing those billing processes, but she understands the mechanisms now and is doing that for herself. She's, you know, being with a smaller patient panel, and I think that's kind of the most important piece. She sort of consolidated her panel down to 35 patients and families. When she first got into practice, you know, she was soliciting referrals from primary care providers. They tended to be difficult patients, some of whom had failed with other providers. And, you know, she's kind of winnowed it down now to a manageable 35 patients and families that she can handle, and that, you know, she can keep up with her billing and documentation. So she's assured that she's, you know, documenting daily, getting things uploaded to the system from Dragon when she does. And again, she's seeing, yeah, up to 4 patients a week, 3 to 4 days a week, and she's reporting that she feels confident that she can keep on top of their care. And again, there's really, aside from patient one's guardians on this, you know, issue of her records, there hasn't been patients complaining about her care. They're ostensibly happy with her care, and she's continuing to do the consulting that she's doing within those larger organizations at, I think it's Brook. Yeah, so she's continuing to do, you know, consultation with some supervision at these facilities. So I hope that answers your question.
Yes, but I'm
Greenberg.
not sure I understood one part of it. Just to follow up on that, you said that she's seeing up to 4 patients a week now. Did I hear you correctly?
I'm sorry. Thank you for clarifying. So she says, I'll be seeing up to 4 patients per work day, 3 to 4 days per week. I am confident I can provide thorough patient care, documentation, and billing on a daily basis. That's exactly what she said.
Thank you.
Dr. Greenberg, did you have a question?
I did, and you may not be able to answer this, but just if there was a reason or a rationale for discontinuing care of patient 1 while she was admitted to Brattleboro?
So she had been admitted she had multiple hospital admissions, I think up to 11, and was at a facility sort of new. She was newly had turned 18. She was living in a residential facility setting. She had run away on more than one occasion. There have been multiple hospitalizations, and Dr. Sakaria was really just advocating for some changes in her medication, and her guardians were not in favor of that. And there's some emails in the evidence that would come up later where they clearly came into the care kind of predisposed against medication changes and increases because they felt probably genuinely so like she had a long way to go in her care and didn't want to go too high too quick on some of the medications. And I think what Dr. Sakaria would say is, I have a patient here who's suicidal and being hospitalized, and she needs medication changes, and they wouldn't allow that. And so then she said, well, I can't continue to see her if I'm not able to do what I think is really necessary. So that was kind of the crux of the falling out.
Thank you.
Ms. Falk, did you have a question? You're muted right
muted.
now. We can't hear you.
Right. Yeah, I had maybe 2 questions. One is, does Dr. Sicario treat patients at Brookhaven and the other facility, or what is her role for those patients?
Yeah, so my understanding is that she does some consultations there for medication management, primarily.
So she is an active physician for those patients as well as the 35.
On a consulting. I'm sorry.
What do you mean on a consulting basis?
I think she's called in. I think they have an attending physician at those facilities who then have her consult, or at least there's I wish Dr. Sakaria could just answer the question here.
Okay. All right.
But I know that she's seeing patients there. My understanding is on an as needed basis for medication management. That's my understanding.
Okay. And does she have any idea about what she would do, what would happen to her patients if this motion were granted to suspend her license?
We talked about that briefly before coming on, and I mean, I think when a license is suspended, patients have to be notified, right? That she can no longer see them clinically, and that and then she would have to help make arrangements for, to make sure they have medications for the next 30 days and to perhaps make referrals to other providers. I mean, it's obviously, significant for them and for her.
Thank you.
Dr. Kadir?
Yes, Mr. Smart. The state alleges that records were requested, I believe it was in February of this year, and just received recently. And there's also allegations that the date of the signature, I believe, or the completion date does not seem to jive with the actual visit date. Is it your claim that these records existed and for some reason couldn't be transmitted to the board? Or did these records not even exist?
Oh no, I know. My understanding is that they existed. And she would have to explain further why they didn't get culled in response to the subpoena. But my understanding is that they've existed. I mean, they're certainly were not prepared, after the fact. I mean, again, she would have to explain whether if there was anything that was on, her dictation that hadn't been transmitted to a note or some combination of those things. But the documentation is contemporaneous. It just either didn't get into her system or wasn't pulled from her system in response to the subpoenas. And I mean, it would have been to her benefit to do so, clearly.
Ms. Philbert?
I have two questions. The first is a legal process question. Why isn't she able to provide information? You said, I wish she could speak. Why is she not able to? Maybe Judge
Maybe-
Belcher, that's a question for you. I don't know.
Sure. The resolution before the hearing was that the board would be presented the request for the summary suspension and the answer, and that council would be able to address it. But this is not, it is a summary proceeding where the board would act on the alleged facts. And thus, if we, I'm sure Dr. Sakaria would love to chat and explain herself, but if we did that, she would be put under oath. We would embark on a evidentiary hearing that would probably take several days.
Okay, thank you. My second question is, and I don't remember exactly at what point this was mentioned when Megan was reviewing the history, but there was a point at which she said certain specific medications were prescribed, but there were no medical records. How are we to know that those medications were prescribed if there are no medical records?
May I field that question?
Sure.
From my perspective, yes. I don't know who answers that.
There is the Vermont prescription monitoring system, which is going to capture certain controlled
So
substances
she was using
that
it by
are
then.
prescribed. It wasn't that she was using it, it was that it was pulling prescribing data. So she was actually not using it.
Okay.
But it was still collecting data
Okay.
about her prescriptions, which the board was able to access to determine that there were prescriptions happening in the absence of medical documentation.
Thank you. From the dispenser. Thank you so much. Okay.
Yeah, so I would submit that, I mean, it presents an issue of whether on that occasion she had fallen behind on her documentation. What I would submit the import that is.
Are there any other board member questions for Mr. Smart? And unless there are further questions for anyone, let's see. Dr. Kader, did you have another question?
I do, and this refers to the Vermont prescription monitoring system, and I'll direct this to Mr. Smart. You said that she was apparently not aware of the requirement to use the Vermont prescription monitoring system because it was not used in the Minnesota residency training, I believe. It's rather difficult to obtain a license without being noticed that there is such a system in place. Is it true that it's not used in Minnesota and that's why she was unaware of it?
No, I think every state has their own analog of that. I think what she's been saying to me is, I mean, she had some awareness generally that these systems existed. It wasn't something that she interacted with during her residency or at Dartmouth during her fellowship. And I don't fully understand, to be honest, why, you know, when you make prescriptions within that setting, that clinical setting, you aren't querying it, where the responsibility isn't on you to do that in the same way that it is, you know, when you're in private practice. So I think that's.
Thank you.
Any other questions for Mr. Smart? Or any other questions that we need to deal with? If not, I would ask the board whether there is a need and motion to enter a deliberative session.
I would like to make a motion to proceed to deliberative session.
All right, thank you, Dr. Greenberg. Is there a
I'll
second?
second that.
Second.
All right, thank you, Dr. Tando. Dr. Tando, were you seconding or did you have a question?
I was seconding to go into a
Alright.
deliberative session.
Okay, thank you. I'm going to ask everyone, all the active board members, to raise their hand if they want to enter a deliberative session. Please do so now. Are there any who oppose? If so, please raise your hand now. All right, thank you. So there's a majority of board members who would like to enter a deliberative session. I'll just quickly go through this. I understand the board is familiar with how to do this, but board members who are entering the deliberative session, there's a second link to do that. If you leave this session, you can do that. Or if you keep this session open, you certainly need to close your camera and your mic so that what you say in deliberative session is not transmitted. And for those who are not entering the deliberative session, you can simply keep this link open and we'll return to this this format as soon as we're done in deliberative session. Any questions about how to enter the deliberative session? All right, we'll go there then now. Thank you.
George, just South members are not going into session, correct?
Yes, that's right.
Thank you.
And David, did you want to say anything about that?
No, I think that all worked out fine.
All right, thank you.
Thank you.
Dr. Sakaria, you can probably turn off your camera and while they're in there. Okay.
Hi, Judy. If you were trying to get into the deliberative session, you just came back into the regular meeting. You're on mute. You should have gotten an email from Kelly with the link.
David, I wonder if I have to go in and get them out of the waiting room
Oh,
because I created the meeting.
yeah. Why don't you? Yeah.
Okay.
All right, so I'll go back and try again.
Okay, great.
Any rent checks today? Any rent checks today?
I'm just taking the roll here. Is Ms. Scott on the line?
Yes, I am.
Oh, great, thank you. And Dr. King, are you on the line?
Yes.
Is there?
Great, thank you. So I think we're reconstituted. We're still on the record. We're returning from deliberative session. And I would ask the board whether there's a motion concerning this matter.
Yes, there is, Judge. I would like to make a motion that we reject the summary suspension at this time.
All right, is there a second to that motion?
I'll second that, Philibert.
All right, I'm going to call the roll. When your name is called, please vote yes or aye or no or nay. Mr. Chiapinelli,
Yes.
Dr. Kader,
Yes.
Dr. Eiler,
Yes.
Ms. Falk,
Yes.
Dr. Gades,
Yes.
Dr. Greenberg,
Yes.
Dr. King,
Yes.
Ms. Philibert,
Yes.
Ms. Scott,
Yes.
and Dr. Tando.
Yes.
All right, that is unanimous. The vote passes, and we'll prepare an order for signature by the vice chair. I believe the vice chair wanted to quickly address the respondent.
Yes, I just wanted to be clear that during our deliberations, there were grave concerns about the behavior and the information that was relayed to us today. However, in balancing the needs of the 36 or so patients cared for and the potential harm for ongoing treatment versus lack of treatment, we felt that the normal due process should be continued. There are still great concerns in a number of issues that clearly need to be addressed by the South Investigative Committee, and we'd like that process to proceed.
Thank you, Dr. Greenberg. Unless there's something further concerning this matter, that concludes this matter. Thank you very much. Thank you, board members. Thank you, council, and I will take my leave.
Okay, thank you, George.
Thank you, Judge.
Thanks, George. Okay, returning
Rick.
to our, sorry, go ahead.
I was wondering, for those of us that were in the deliberative session, could we just take about a minute to grab a drink of water?
Sure thing. Why don't we
Bio-
make a motion to go into executive session and then we can take a couple minute break?
All right, I move that we go into executive session. Philibert?
Can I get a second?
Second, Tando.
Any discussion? All those in favor, please say aye.
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 Any opposed?
Hey, Rick, I will be a
Abstentions.
little late coming into executive session because I have a patient to see.
That's fine. We'll see you all in executive session in a few minutes.
Thank you, Rick.